Hi guys, welcome back to Battle with Ola. This is Mujola Olua and I'm so thrilled to be here once again. Thank you so much for tuning in. On this episode, I want to talk about matrimonial property in Nigeria or marital property in Nigeria. But before I go on, I'd like to give two announcements. The first is that thank you so much for all those who have been engaging with my community posts. My community posts are posts that are not video in nature, pictures, posters, and whatever that I've been putting on the community section of my channel. And thank you so much for all the feedback. I know that we've been having a swell time, exchanging, engagement on that portion of the channel. But someone recently messaged me and said that they could not find the link to an internship opportunity that I had shared. Now, I do not delete my community posts, and YouTube does not delete it either. So what I want to say is that if you're looking for a post or something that I've shared that you cannot find, just click on my channel, go to the community section, and then scroll down. You will definitely find it. The second thing is that someone suggested that I should also start doing podcasts. Thank you so much for your lovely thoughts, but I don't think I want to get into podcasts yet. But I have an idea. You can listen to this channel like a podcast. All you need to do is plug in your headsets or put it on hands-free, and then you can listen to it without having to look at the screen and go about whatever it is you want to do, just as if you're listening to a podcast. It works. I know that someone had left a comment saying that that's how they do in the mornings while they're doing their other chores, and I know that it can also work for you. So you can try it. You can just put the videos on autoplay so that one plays after the other. The only thing is that the only difference is that if I'm typing out something on the screen, you might not see it because you're listening to it. But the channel works both for audio purposes and visual purposes. Thank you so much. So now let's talk about matrimonial property in Nigeria. The first thing you need to know about matrimonial property in Nigeria is that it does not exist. No, nothing like matrimonial property in Nigeria. Very important for you to understand that. I've done a video on divorce, and I've done a video on divorce in customary marriages. How you can end a statutory marriage and how you can end a customary marriage. Those are the two types of marriages that we have in Nigeria. Now, after ending the marriage, how do you divide, or while ending the marriage, how do you divide the property of the marriage? That's what this video is about. Now, this video is not an advocacy for people to end their marriages. No, marriage is a beautiful institution. I respect it. I have so much reverence for it, and I hope that one day I will join that institution as well. But these are discussions that we need to have. And don't forget that I'm just providing a legal perspective to this. I'm not advocating for divorce. Please be advised that I'm only providing a legal perspective to this. I'm not advocating for separation, for divorce, or for distributing or dividing marital property or property owned by couples in marriages. So, but let's talk about this. But this is an important conversation, and we're going to go ahead and have it nonetheless. So there is nothing like matrimonial property in Nigeria. The law does not recognize you owning a property as a couple, or the property being the property of the marriage. I know that it's obtainable in some jurisdictions, but if you're a Nigerian, don't get carried away with the films that you watch, where when they are getting a divorce, someone will say that, okay, they want to split the property 50-50 or 70-30, or as the case may be. You would even find in some movies that they are not only laying claims to the property of the marriage, but the property before the marriage and after the marriage. When I'm talking about property, I'm talking about both movables and immovables, real property and intangibles. I'm talking about shares, I'm talking about earnings, royalties, I'm talking about land, cars, houses and whatnot. So in Nigeria, we do not have such provisions. What the law says in Section 72 of the Matrimonial Causes Act of 1970 is that the court should be just and fair in distributing marital property, in settling marital property. So that means that in the event of a divorce, the court will do what is just and fair in trying to divide what a couple is claiming or laying claims to. But it is not automatic. There's no system for it. There's no formula for it. There's no percentage or ratio for it in Nigeria. What you need to do is, if you want to lay claims to any property of the marriage, you need to ask for it specifically. Okay, you need to ask for it. And while asking for it, you need to show proof to the court that it is actually your own. Very important. In Kafi and Kafi, it's a decided case, a Nigerian case. The wife was able to show to the court that she contributed emotionally and financially to the wealth of the marriage, the properties, gathered during the marriage, owned by the couple. So or owned by the husband, as the case may be. So the court awarded her a house at Ilupeju because she was able to show proof that she contributed to the ownership of the house. And in Onobolu and Onobolu, the court held that a party that is claiming ownership must be able to show the actual extent of their ownership. For instance, if you're laying claims to the matrimonial home, if you're saying that, oh, my husband and I built this house together, you have to be able to show to the court the extent of your contribution to the ownership. Or when you were buying the land, maybe you paid 50% of the purchase price. You have to show that to the court. Maybe when you were building, you paid some monies for cement, you paid for workmanship, you did this and that. You have to show it to the court. Now, am I encouraging people to start keeping receipts? No, I'm just telling you what the law says. So make of it what you will. But in a Nigerian court, or in the event of a divorce, you have to prove what you're claiming that you own. There is no free lunch. And in some instances, according to Section 72 as well, if you look at subsection 3, the court might settle the property for the children of the marriage who are under 21 years old. In some other instances, the court could settle the properties for those who are above 21 years old, but you can look at that section of the law, Section 72 of the Matrimonial Causes Act. Essentially, what we are saying is that the court does not recognize that by virtue of being Mr. So-so or Mrs. So-so, by virtue of being married to somebody, you now own anything. No. How then is a matrimonial property, in quote, viewed in Nigeria? It is viewed as if, as normal ownership. That is, if I buy a plot of land now, it is my land. The same way, if I were married to someone and I buy a plot of land, it is still my land. It doesn't mean that it is now common property because I bought it. If I want it to be common property, then I would execute the documents of that land in the names of everyone whom I want the document to reflect as the owner. So if I'm buying it for myself, for my child, for my husband, it will now be Mr. So-so and Mrs. So-so and son or daughter so-so and then our surname. So it's not even safe for you to just have Mr. and Mrs. I know that last year, a senior asked me to help them draft an affidavit for an acquaintance of theirs who had bought land several years ago as Mr. and Mrs. So-so. So the man came and said that he now wants it to reflect the full government names of himself and his wife. So Mr. Shade Koka. So Mr. Olu Koka rather and Mrs. Shade Koka. Very important, especially for women, because anybody can be Mrs. Koka, in the future. Any God forbid bad thing, anybody can be Mrs. Koka. So when you're saying Mr. and Mrs. So-so, what you're saying is that whoever is filling that spot at a particular point in time is now the owner of the property. It's debatable, but that is what it can come to if it's a property that is in contention. So the safe way is to execute it in your full government name. If you are a husband and you want to buy a car for yourself, you are Mr. Adekoka. You buy it in the name of Mr. Adekoka. When it comes to court, the settlement of the marital property or the property owned by the people in the marriage, nobody will contest it with you. So that is how to own property in a marriage in Nigeria. Own it as if you're owning as an individual, or execute the ownership documents in the name of everyone whom you want to claim ownership in the future. So there's no automatic ownership. I know that there's room for settlement, so it's important. I know that we were in one customary divorce matter at the magistrate court several years ago, and a few years ago actually, and I'm still a young lawyer, so there's no need for several years ago. So actually in that matter, after some messy fightings in court, the court ordered that we should do a settlement. So during the settlement meetings, the husband insisted that he wanted the matrimonial home. The wife insisted that she had literally built the house from her sweat and she wasn't letting go. But because she had built another house, the husband was saying, go to that house, leave this one for me, and all of that. And she was taking the children along. So if the parties are reasonable, in settlement, you can divide property anyhow you want. The court is not against that. So you can say that, okay, I give you this car, you can take it so that you can take the children to school since you're going with the children. Or I give you that house, I know that it has sentimental value to you. Or I give you that plot of land, I bought it for you anyways, and it's okay, you can take it, Property can be divided any way and anyhow once there's no fighting. But when there's a contention, that is when this thing that I'm telling you will now come into play. That is, he who asserts must prove. So if you are claiming something, you have to prove the ownership. There's no automatic ownership for you. But in that case, eventually we were able to prevail upon the wife that since this man would not let it go, and it became like a gridlock because we had reached some other settlements and we're making progress because of that point and one other point, we decided to prevail upon the wife that just let him be. You're a rich woman, you have your property, you can just move on with your life and all of that. So she gave up the property and we were able to return to court with the settlement. I'm not saying that people should start giving up their own properties, but I'm saying that in the interest of peace, that was what happened because they still have children together. So, we were just trying to foster peace in that situation. So I'm just giving that as an example. So that's what can happen. You can agree during settlement meetings that this is how we want to share the things that we both own, or the things that either party feels that they have lawful claims to or ownership over. So you can then present that to the court, or you can also infuse it into your claims before the court. The ones you're letting go, the ones you're not letting go. But there is no matrimonial or marital property in Nigeria. Let's talk about prenuptials. Prenuptials are agreements that are signed by parties who intend to get married to preclude them, or to preclude one party from laying claims to the other party's pre-marriage earnings and wealth. So if, for instance, there's a popular footballer now, who has made a lot of money and then is now trying to get married, so he could execute or he could bring up a prenuptial contract for the prospective wife to sign. Or if there's a popular model or a popular rich woman or rich man who has made a lot of money and who does not want to share it with the person whom he or she is now married to, in the event of a divorce or a determination of their relationship, they can execute a prenuptial agreement. You can read up on that to ensure that if the marriage or the relationship does not work and then they are trying to go their separate ways, one party will not lay claims to what the other party had before the relationship or the marriage came into existence. And there's postnuptial too. That one you can sign or execute to cut off a party from laying claims to the post-marital earnings or income or wealth. That would apply to maybe creatives, for instance, people who get royalties and people who keep getting earnings even from their creative works, maybe intellectual property, and what have you, to ensure that, okay, you don't continue to claim from what I own even after the marriage. That's postnuptial. And prenuptial, what I own before the marriage. So now that means that in the event of a divorce, they are going to limit their division of property owned in the marriage, or income or wealth, to what was owned during the subsistence, or what came into being, or what was accumulated during the subsistence of the marriage. And even when it now comes to that, in Nigeria, there is still no guarantee. You have to prove and show proof to the court. I read one Ugandan case one time when the wife was claiming that she's entitled to the earnings of a man from a certificate, that a qualification he obtained during the marriage, because while he was busy studying for that qualification, she was taking care of the home front, supporting him financially, emotionally, supporting him emotionally, and mentally, and generally, taking care of him and supporting him. So the court found merit in arguments and granted her a percentage of the earnings from that certificate. It's interesting. You can look it up. I think it's an Ugandan case or a Kenyan case. But that's not the case in Nigeria. What I'm saying is that whatever the case, he who asserts must prove. So that's about prenuptials and postnuptials and settlement. Of course, those are other instances where you can delineate how property will be shared. But as far as the law is concerned, Section 70 says that the court will do what is just and fair. So it is entirely at the court's discretion, and the court has shown us what it will do. In the case of Onobulu and Onobulu, in Kafi and Kafi, and in a plethora of other decided cases, the court has shown that whoever can prove to its satisfaction that they actually own something, that is the person that will get whatever they are claiming from the court. So what are we saying about ownership of matrimonial property in Nigeria? We are saying that it is not in existence. The law does not recognize it. However, whatever you bring into a marriage, you are allowed to take out of it. Whatever you acquire during a marriage, you are allowed to take out of it. Whatever you own post-marriage is yours. So the ball is really in your court as a wife or a husband, and it's important to protect your interests and the interests of the spouse that you love, so that things are properly delineated and ownership is specifically, outlined in a marriage. Now, there are some other lawful provisions that we should look at. For instance, the Married Women's Property Act of 1882 protects the right of married women to own and dispose of property. That simply means that as a wife, you don't have to buy property through your husband. You don't have to ask him for permission. You don't have to be subservient to him in the aspect of owning property. You can own property. You can buy property. You can dispose of property. That's the provision. It does not mean that because you're a wife, you now automatically own everything that belongs to your husband. If your husband does not intend for it to be so, and if it's not clearly spelled out in documents and well proven, it does not belong to you. But it says that you can own your own property as well and dispose of it as you see fit. How about the Marriage Act of 1990? It's applicable in Nigeria, and it recognizes the right of men and women in marriages to own property as equals. So you can own property as equals in a marriage. That means that a man can own his own property, dispose of it. A woman can own property, dispose of it. And if a property is co-owned, both parties have a say over it as to the management, the disposal, and the exploitation of that property. That's the provision of the Marriage Act of 1990. How about cases of death? So let's talk about two options. We have wills and codicils, and then we have intestacy. In the case of expected or anticipated death, a man or a woman can make a will devising the property that they own to anyone as they see fit, to their wife, to their husband, to their children as they see fit. And such person will own it by virtue of that device, and that legacy. So you can give your property to your spouse, in a will. How about if someone dies intestate? There's a line of succession, and in that line of succession, the surviving spouse comes first. So the people that are entitled to seek letters of administration in order of priority are the surviving spouse, so that is the living husband or wife, and the children of the marriage. And then the other people now come, other relatives, maybe grandchildren whose parents have died, and then the father and the mother, and so on and so forth. But your spouse has the lawful right to obtain letters of administration to now own and begin to administer your property in the event that you die without making a will stating who the property goes to. So these are the provisions of the law on property owned in a marriage, or property owned by people in a marriage. But there's no express provision that says that because you're in a marriage, you automatically own property, and when you're leaving, you take this percentage or that percentage with you. I hope that this is clear. So property is basically owned as an individual in a marriage, and the person that is claiming certain property must prove the same, whether it's customary marriage or whether it is statutory marriage. But there are special provisions but there's a specific provision for statutory marriage, and that is that the court will do what is just and fair. And I believe that is applicable for customary marriage too. Whoever is supervising the determination of the marriage will also, of course, do what is just and fair. So that's all I have for you in this video. I hope that it is clear, and I will see you in my very next video. Don't forget to subscribe to those.